Good day, everyone, and welcome to yet another enlightening webinar session with immigrationquestion.com. On today's episode, we will be touching on buzzing subject in the immigration world, the impact of recent changes on asylum and deportation defense. My name is Maliha, and I'll be your host for today's discussion. So today we'll discuss on some key changes impacting asylum seekers and immigrant facing deportation and how lawyers can adjust their strategies to navigate these challenges. With me in today's session is one of the reputable attorneys we have registered on our lawyer network. He is a distinguished authority in U.S. immigration law. With over 15 years of experience in immigration law, Mr. Lal is knowledgeable in all aspects of business immigration matters and has consistently guided the business towards unprecedented success and excellence. Welcome, Mr. Sonulal, and thank you for availing yourself today.
Thank you, Malia, for that kind introduction.
So, over the past few years, we have seen significant changes to immigration policies and procedures in the United States, from new restrictions on asylum applications to increased immigration enforcement and deportation. These changes have made the work of asylum and deportation defense more important than ever. So, do you have any insights on this, Mr. Sonulal?
Over the past few years, there have been so many developments in general within immigration law. Since we are focusing our today's discussion on asylum and removal defense, I'll talk about a few things about those developments. I'll start with the very recent development that very recently happened, like last month. President Biden issued a proclamation. uh, Essentially, what that proclamation does is it restricts asylum seekers' ability for asylum. What exactly it does, that proclamation and the accompanying executive order says that if the DHS, the Department of Homeland Security, uh, announces that on an average, the apprehension at the border, the illegal entry at the southern border, if on an average it increases 2,500 per person, then what will happen is any person who is entering through the US border between the port of entries. So this term confuses normal people. Between port of entries means anybody entering not through the port of entry. They're entering through the US border from the southern border with Mexico. If anybody entering through those borders outside the area of port of entries, then they will not be eligible for asylum, even if they apply. There are certain exceptions to it, but in generally, they will not be eligible for asylum. Even if they, let's say, they enter the US and nobody apprehends them. The CBP agents, they don't apprehend it. They are already in the US and later on they apply for asylum. Since they entered within that period where the DHS announced that the daily average is $2,500, 2,500 people or more. So based on that, even if any person apply for asylum, the asylum will not be granted. And even if that person is apprehended, that person will be sent back to the country. They will not be normally people are, even if they're apprehended, they are able to seek asylum. But with this executive order, they will be sent back. So this is the most recent thing. We have not heard any reports, the actual report, what the progress on it on the ground as we hear more about implementation of this executive order, we'll be probably have more to say about this issue.
Absolutely, Mr. Sonulal. I totally agree with you on that. I think we have someone from the audience who'd like to speak. Mr. Logus, you can go ahead and ask your question if you have any. Mr. Logus. Okay. So, like you very rightly said about the Biden program, what are some of the recent changes under the Biden administration that will affect asylum and deportation in the United States?
So besides this recent executive order and proclamation, over the last year, the Biden administration has proposed to make the what is called the credible fear interviews. So if you are entering the US and uh, let's say you are either put into expedited removal proceedings and then you are saying that I want to apply for asylum, then you go through what is called credible fear interview. Now, what the Biden administration is going to do is they are raising the standard of that credible fear interview. In general, what it means is the officer who is not an immigration judge or asylum officer will have much more power compared to now to not grant a hearing to that person and remove that person from the US. This is a significant change that the Biden administration is going to do.
Well, that's really interesting and beneficial as well. So, moving on to our next question, in recent months, the Biden administration has struggled to handle the influx of migrants, including unaccompanied minors arriving at the southern border. The administration has maintained Title 42, Trump era public health order that allows border agents to quickly expel migrants, including asylum seekers. What is your view about this? Are there really any exemptions?
So, Title 42 was actually initiated during Trump administration during the COVID period. What Title 42 essentially says that on public health ground, anybody entering the US can be sent back. They will not even be able to apply for asylum. Of course, there are certain exceptions and exemptions. Exceptions means anybody who's a US citizen, anybody who's a green card holder, anybody with a valid visa, there were exception to that Title 42. And there were certain exemptions also. Based on humanitarian ground, the people will still be let in. But when the Biden administration came into power, later on, they tried to end this Title 42. And then later on, there was a court challenge against the Biden administration. But finally, the Title 42 has been lifted. And my view on Title 42 is that it increased the government's power to not allow people to seek asylum in the United States. It's not, it was a little bit, it seemed right at the time of COVID time because the COVID was a big risk, but later on, it did not make much sense. And then finally, now it has been lifted.
Thank you so much for the valuable insight, Mr. Sonulan, and your views on the specific situation. We have two questions coming from the audience. Thank you so much, Mr. Toin, and thank you so much, Mr. Logus, for interacting with us today. So, Mr. Toin has a question: how does deportation proceedings work, and what are the rights of individuals facing deportation? Mr. Logus has to say, please do you answer H1B visa related issue questions. We are going to go one by one. Mr. Toin, that's your turn for it. So it's how does deportation proceedings work and what are the rights of individuals facing deportation?
Okay. So let's say you are in deportation or so-called removal proceedings, which means the government has started proceedings against you to remove you from the United States. So you will be send what is called notice to appear. It's called NTA. The NTA will say the charges that why you should be removed or deported from the United States. And it will also say the time and date where you have to appear for the proceedings. The first hearing in any immigration proceedings is called a master hearing. It's generally a short hearing. You go before the immigration judge, and then the immigration judge would go through the NTA. And if you have an attorney, then the attorney will speak on your behalf. Or if you do not have attorney, the immigration judge will give you some time to retain an attorney to be represented you in these removal proceedings. So once this master calendar hearing is done, normally at this master calendar hearing, the judge will go through the NTA and the judge will ask what relief you are seeking in the immigration court from the removal proceedings. Most common form of relief is asylum. There may be other reliefs such as cancellation of removal, adjustment of status, or maybe other kind of reliefs. So at the master calendar hearing, the judge will assign you an individual hearing or a merits hearing. The merits hearing or individual hearing is where the judge will go through your relief application. Let's say you have filed an asylum application. The judge will go through your asylum application, your supporting documentation, and then the judge will issue decision whether to grant asylum or not. This is how normally the removal or deportation proceedings work. Now, what rights you have? The most important right is that you have a right to be represented by an attorney. What most people confuses this right as they think of it as a criminal code where the attorney will be provided at the government expense to you. It doesn't work like that in immigration proceedings. Although you have a right to be represented by an attorney, but you have to hire an attorney at your own cost. The government will not provide you an attorney at its own cost. So you will have to find an attorney, pay for it, or if you're not able to pay, then you can probably find some organization who do pro bono work, and then you can probably will be able to retain an attorney at no cost. But there are very very few organizations who works like that. It'll be very hard for you to find such an attorney. It's the most important right in an immigration proceedings. Besides that, you have a right to communicate, you have a right to give your testimony, you have a right to provide evidence in support of your claim. Let's say in a removal proceeding or a deportation proceedings, you are claiming asylum as a relief, then you have a right to present evidence to support your claim. What documents you can provide? You can probably provide affidavits from family and friends uh, who are familiar with your case, who can vouch for you, who can write affidavits for you. That's one thing. You can also provide country condition report issued by U.S. Department of State or some international organization. Another interesting thing is you can present expert testimony, meaning if there is something going on with your situation or in your country and there is a expert on those issues, then you can hire that expert and bring your expert to the court who can testify about your claim. So this is how the whole removal proceeding works, and these are the rights which I just listed.
I'm so sorry about that. So we have our next question that's from Mr. Logus. Please do you answer H1B related questions.
Although it's about asylum, but yeah, we definitely can answer. We can definitely answer about H1B.
Mr. Logus, you can elaborate any question that you're having. The next question that we have is from Mr. Ojo. We also have Mr. God's favorite and Mr. Habib in the queue. So, Mr. Ojo's question is, what are some of the ways someone can get asylum in the United States? Can I get asylum if I am being abused?
Well, that's a good question. So, if you are already in the US and you are a victim of abuse, maybe gang violence or any other kind of abuse, and there are certain factors for asylum, certain grounds for asylum. One of those grounds is if you belong to a particular social group. There is no fixed definition who falls under particular social group, but in general, if you are a victim of, let's say, for example, a gang violence, then you can claim that you belong to that particular social group where you are a victim of gang violence, and then you can be eligible for asylum. So just to simplify the answer, yes, you can be. But it will depend on more facts, and when you actually hire an attorney, then he can go into your facts of the case in detail and then provide you right direction, way to go.
Absolutely, Mr. Sunulal. Thank you so much for the valuable insight. The next question that we have is from Mr. God's favorite. That's, can I get asylum in the United States if I have dual citizenship?
People who have dual citizenship will have a harder time to claim asylum because the government is likely to argue that, let's say, if you cannot go to the country of persecution, since you are also a citizen of a different country, you can definitely relocate to your country. So it will be very hard people with dual citizenship to be eligible for asylum.
Thank you so much for the valuable insight, Mr. Sunulal. Moving on to our next question. I have a question. What are the best options for bringing family members to settle in the United States?
This is a family immigration question, but in any case, to bring the family, there can be several avenues to bring your family. Either somebody sponsored you already, and then your family member, your wife, and your children, or your husband or your children can come as derivative beneficiaries. So somebody filed for you an immigrant petition, and then your spouse and your children can be derivative beneficiary of that petition. That's one way of doing it. Another ways is where you were sponsored for an employment based either non-immigrant visa or an immigrant visa. Again, your spouse and your children can come with you as your derivatives. So these are the two most common ways that people bring their families to the United States, either through family-based immigration or employment-based.
Thank you so much for the valuable insight, Mr. Sunulal. We have a question from Mr. Muhammad. What impact do criminal convictions have on deportation cases?
So if you are in a removal proceeding or the so-called deportation proceedings, and if you have a criminal conviction, then it will be very hard for you to get any kind of relief from those removal proceedings. What happens in removal proceedings, once you are in removal proceedings and you apply any kind of relief, let's say you apply for asylum, then government would request you to submit what is called biometrics, meaning you will have to go to a specific location and give your fingerprints. What happens after that? The government will do the background checks. The purpose of the background check is to ensure that you do not have any criminal history. If you have any kind of criminal history, you cannot get most of the immigration reliefs. Specifically, you cannot adjust your status. You probably will not be eligible for asylum also. So if you have a criminal conviction, it's a very big deal to getting any kind of relief when you are removal proceedings.
That's sad, but thank you so much for the valuable insight. Mr. Sonulal, moving on to our next question. I'm from Guyana. My asylum application is being rejected. Can I appeal again?
So from the question, it's not clear whether it was actually the case was actually as USCIS or at immigration hearing. We'll answer both the things. If the case was at USCIS and the asylum was not approved, then what happens is the case is referred to the immigration judge, which means the person will have another chance before the immigration judge to renew his application, and then the immigration judge will decide whether to approve or deny the asylum application. And if the case was in the before the immigration court and the immigration judge denied the asylum application, then this person can file an appeal with what is called Board of Immigration Appeals. But there is a certain timeline. Within 30 days, the appeal should be filed with the BIA unless some exceptions apply.
That's very interesting, Mr. Sonulal. Moving on to our next question, it was from Mr. Muhammad. Or we have a question from Mr. Lewis. What major evidence is needed to prove an asylum claim?
That's a great question, and it even confuses many attorneys also. What actually you can provide, what you cannot provide. If you are applying for asylum, the most weight that the judges give to is your own statement, is your own testimony. So your written statement and your testimony during the merits hearing is a great piece of evidence. Besides that, what evidence you can provide are as follows. You can provide statements from the people who are familiar with your case. Meaning, let's say uh, you were injured in your country back home for being a member of LGBTQ community. Then your family members can give affidavits that these things happen to you in writing, that you are beaten, you are a member of your and you are a member of LGBTQ community, your family, your friends, people who are familiar with the facts of the case. That's one set of documents. And then if you went to the hospital, you can provide hospital records. If you filed a police complaint, you can provide a police complaint. And you can also provide what is called country condition report. The US Department of State issues country specific reports almost every year. And in that report, they describes what's going on in that country, what are the challenges. You can provide those reports. You can provide reports from international organizations such as UN, Amnesty International, etc., etc. If those reports highlight what's going on in your country, those reports are relevant. You can also provide uh, a psychological evaluation of your state of mind. That also the judges give weight to that also. And as I said before, you can also provide expert testimony, meaning you can hire someone who are experts in issues which are related to your case, and they can testify before the immigration judge in support of your case. So these are the evidences that you can provide in your at your merits hearing.
Absolutely. Thank you so much for the valuable insight, Mr. Sonulal. If you're just joining us, this is immigrationquestion.com live webinar session. Immigration Question is a revolutionary platform that connects immigrants and users with qualified immigration attorneys. You can ask your questions for free and you'll be connected to a verified attorney registered on the platform. For immigration attorneys, this is your opportunity to scale your practice to next level. Register as an attorney and get up to 10 free client leads upon sign up. Back to the subject, Mr. Sonulal. Can someone be deported if they have already been granted asylum?
No. So if somebody been granted asylum, which means the government is authorizing to stay in the US. And once you have been granted asylum, after 1 year, you are eligible to file what is called legal permanent residence or green card. So which means after 1 year of granting asylum, you can file for your green card.
Thank you so much for the insight, Mr. Sunulal. Moving on to our next question. In the fiscal year 2023, statistics show that over 30% of asylum applications were denied at initial decision. What are the common reasons why asylum applications are denied? What mistakes should applicants avoid when filing the asylum? Also, we have a question from Mr. Hussein. I'm so sorry for interrupting. What are the key factors that can have me grant asylum to the USA as a Nigerian? Will Trump winning the US election make the process easier?
It's hard to say whether, if the Trump administration comes back, whether it will make it easier or harder. It's hard to say at this time, but just to clarify, for filing asylum, you have to be within US. If you are outside US, you cannot just apply for asylum. So just to clarify to that question.
Absolutely. Thank you so much, Miss Steph. If you have any question, you can go ahead and ask it. So, moving back to my question again, in the fiscal year 2023, statistics show that over 30% of asylum applications were denied at initial decision. What are the common reasons why asylum applications are denied? What mistakes should application applicants avoid when while filing the application?
So most common mistakes that we see where the asylum was denied is that the application was not filed properly. What it means is it was filed without any supporting documentation. So when you file asylum, you file it Form 589. If you are just filling out the form and submitting the asylum application and then just going for the asylum interview or your individual hearing, it's not going to get approved. You have to provide supporting documentation. Without supporting documentation, it is highly likely that the either asylum officer or an immigration judge is not going to grant you asylum. So what you have to do is, let's say you are claiming asylum on being a victim of a gang violence, then you have to provide a very detailed statement with what happened to you in the past and what might happen if you were to send back to your home country. Plus, you should also provide statements or affidavits from people who are familiar with your story, who can vouch for your story. Plus, if you are actually physically injured and if you filed a police report, you should be submitting supporting documents such as police report, such as a doctor's note or hospital records. You should also submit country condition reports. And if possible, people who are familiar with uh, your case should be willing to testify for you, especially if you are in immigration court. And then many judges allows video testimony, meaning even if the people are not with you at the time, they can still testify through video testimony just to make your case stronger. So those are the reason uh, because of those reasons the asylum gets denied. And very often we see that.
Thank you so much for the valuable insight, Mr. Sonulal. So, if you're just joining us, this is immigrationquestion.com live webinar session. Immigration Question is a revolutionary platform that connects immigrants and users with qualified immigration attorneys. You can ask your questions for free and you'll be connected to a verified attorney registered on the platform. For immigration attorneys, this is your opportunity to scale your practice to the next level. Register as an attorney and get up to 10 free clients upon sign up. Back to the subject, Mr. Sonulal, to wrap up, what advice would you give to someone considering applying for asylum in the United States? What steps should they take to maximize their chances of approval?
Uh, I have seen so many people coming to our office after filing an asylum application, which means they have already filed it without an attorney present. So, and when we review their case, they file very weak applications. Those applications have very less chance of being granted. So, I recommend if you are in the US and if you're going to file an asylum application, please seek guidance with an immigration attorney. Do not file on your own.
Absolutely, I totally agree on that, Mr. Sonulal. A big thank you to you, Mr. Sonulal, for joining us today. We have come to an end of this insightful session. Do not forget to explore all the immigration question has to offer. Visit our website at www.immigrationquestions.com. Sign up today and start getting your immigration questions answered. Are you an immigration attorney looking to grow your practice with zero cost obligation? Register on immigrationquestion.com and have up to 10 free client leads sent your way right away. Thank you so much, everyone, for joining us today and asking your questions. And thank you so much, Mr. Sonulal. I think we have a last question to go with. It's from Mr. Hossein. What is achievable timeline for the immigration process?
If you're coming through employment base or family base, I would say 18 months to somewhere around 24 months.
Absolutely. Thank you so much for the valuable insight, Mr. Sonulal. So, this is the wrap. Thank you so much, everyone, for joining us today. Thank you so much, Mr. Sonulal. You
Thank
all
you
have
for
a great day.